Swayam Prabha. Digital India. Educated India.
Hello all. In continuation to our previous discussion on various facets of IP licensing and the role of Indian Competition Commission, we will also extend our today's discussion where we will look into how the IP licensing criteria can lead to anti-competitive behavior and how it is looked from the point of view of Competition Commission of India. So, in today's class particularly we would look into one of the interesting cases in the Indian competition arena, which is the Monsanto case, where the various clauses in the agreement, how it has led to anti-competitive behavior and how the not only the private seed companies as well as the Ministry of Agriculture are also got aggrieved by its behavior, and they have filed complaint to Competition Commission of India. So, let us discuss this case in length to understand the intricacies. So, before going into the case, let me tell you a little bit about the company as well as the technology involved herein. So, as you all might be knowing, Monsanto, one of the popular companies, basically Monsanto Incorporation of the United States, was the first company in the world to develop as well as commercialize one of these BT cotton variety. This is biotechnologically derived cotton variety, which is resistant to a kind of lepidopteran pest, or which is popularly known as the bollworm. So, the BT cotton basically it involves a technology, or basically it contains a gene from a particular bacterium which is known as the Bacillus thuringiensis. And this gene segment, which is incorporated into the cotton seeds, imparts a kind of resistant to this lepidopteran pest or the bollworm. So, basically earlier the one of the ways to prevent the plant from the bollworms was to apply pesticides, which is a kind of polluting way. It may lead to environmental pollution. But the use of BT cotton not only is a environmental friendly way, but also it very much effectively prevents the attack of the cotton crops from that particular bollworm. So, Monsanto developed this BT cotton variety in the year 1992, and this variety was known as BG1, also known as the Event 531 variety. So, this was developed in United States, and later on this technology has been sub-licensed or licensed to many of this company across the world. So, the BG1 was the first generation of this BT cotton variety, which imparted resistance to this bollworm. Later on, a second generation BT cotton was also was developed by Monsanto, which involved two genes, Cry1AC and Cry2AB, which are and the variety is known as the BG2 or the Bolger2 variety, and it has also other name, Event 15985. So, it is basically protecting the plant against the another bollworm, which is known as the pink bollworm, which has gradually become resistant to BG1 variety. So, the use of this BT cotton has resulted in the reduction as well as in some cases complete elimination of the use of the pesticide by the farmer. So, it has gained a quite popularity among the farmers. So, if you look into the technology, since it was developed in the United States, the technology for the BG1 was never patented in India. However, the second generation of the BT technology, which was licensed under this trademark of Bolger 2 variety, is patented in India, and Monsanto was granted Indian patent numbered 232681. You may find this patent in the Indian patent website as well, which draws a priority from its US application, and it was granted in the year 2009 in India. It was like one of the, may read one of these claims, like the patent claimed for a synthetic DNA molecule comprising a particular genetic sequence consisting of a selected Bt genes which are inserted into the genome of cotton seed. Basically, it has claimed a genetic sequence which is isolated from the Bacillus thuringiensis and which is inserted into the cotton seed variety produced across the world. So, basically it claimed the gene sequence. So, as you know, Siemens patent gives a monopoly over this technology. So, any company who is entering into the licensing agreement with the Monsanto company and willing to insert this gene in the cotton variety to make it resistant for the bollworms will be will be regulated under the terms and condition of the licensing agreement. So, this was the basic facts about the technology. But now coming back to the facts of the cases, the Monsanto, Monsanto Incorporation of the United States has licensed its patent to its Indian joint venture Mahiko Monsanto Biotech India Limited, or which is further will acronymized into MMBI, and so Monsanto gave its technology or licensed its technology to its joint venture Mahiko Monsanto Biotech Limited, and then it the Mahio Monsanto Biotechnology Limited entered into sub licensing agreements with the other seed companies. So, there were nearly 40 seeds company which were in the sub licensing with the Mahiko Monsanto Biotech Limited. And what this company has done, like the 40 seed companies, like they were producing their own seeds, own cotton variety, which may be protected under the Plant Variety Protection Act, and in those varieties they were inserting the technology, using those technology patented by Monsanto to insert the particular Bt gene, which will give the resistance from the pest. So, for the use of the technology, the Monsanto was paid certain amount of royalty, like it is not only for this patented technology, but also the associated know-hows and trade secrets are also involved. So, for that Monsanto was getting certain amounts of royalty. And as the declaration filed by Monsanto itself in the year 2013, it has earned an annual revenue of 6.85 billion rupees in the year 2013. Which comes to approximate 110 million US dollars. So, the technology was quite popular, and many of the seed companies are using this technology as the data submitted by the Monsanto. So, the basic issue was the pricing of the technology, like the Bt technology which the Monsanto has patented, and the charges for this technology was very high as per the complaint filed by the various seed companies. So, as cotton being one of the essential crops, and it is a part of the Essential Commodity Act of 1955, basically the price of the cotton seeds are controlled by the Cotton Seeds Price Control Order of 2015. So, it as per this order, like it has the procedure for fixing the maximum retail price. And this order also makes it very clear that the while the government is fixing the maximum retail price for the cotton seed, it will also fix and regulate the seed value as well as the licensing fee, including the royalty or the trade value. So, which are the licensing, royalty or the trade value are the parts of the maximum retail price for any seed variety. So, now the government has the power to fix the maximum sales value as well as the retail price as well as the royalty and the trade value. So, basically the royalty or the trade value is defined as the amount which the licensor collects from the licensee under the licensing agreement for granting the license for the corresponding technology. In this case, it is the Bt technology or the genetic modification technology. So, the fees charged by Monsanto for this Bt technology was known as the royalty or the trade value. So, and the issue is with the pricing of this royalty or the trade value. So, in 2015, many seed companies like those who were in the sub licensing agreement with the Mahiko Monsanto Biotech Limited company, they filed a complaint to CCI regarding the the high charges, the high prices charged by the Indian joint venture of Monsanto. So, basically all these seed companies who has entered into the sub licensing agreement has they have procured the BT cotton from this Mahiko Monsanto with the upfront payment of 50 lakhs of rupees non-refundable, as well as the recurring fees which is known as the trade value. So, all this company were giving upfront 50 lakhs rupees non-refundable amount, as well as the additional trade value, and the trade value was decided per packet of the seed sold, and one packet in that time it contained nearly 450 grams of the seeds, and Monsanto has fixed the trade value on the 450 grams of seed packets. And as I mentioned, this trade value is that value for the technology. So, the total amount of trade value which the Monsanto Mahiko Monsanto was charging from the sub licensees, some amount was disbursed as a royalty to the Monsanto Incorporation of US, the parent company, as the but the royalty paid to the Monsanto was quite small, nearly 15 to 20% amount of this licensing, the trade value was paid as a royalty to the parent company, but rest of this money was used by the MMBL. So, this pricing of this trade value was not a concern in the year 2015 itself. Since 2005, there were certain concerns regarding the pricing of this trade value, and there are certain disputes or litigations also for that thing. So, in the year 2005, the trade value was decided to be 1250 rupees per packet, of 450 grams, and it was decided by Mahiko Monsanto, and this high trade value has led to the total price of this one packet of seeds, which contain nearly 450 grams of BT cotton seeds, to be nearly 1700 to 1800 rupees, whereas the non BT cotton seeds were at that time were available in 300 rupees. So, you can imagine a gap of from 300 non BT, and it was 1700 to 1800 rupees for this BG1 variety or BT cotton variety, because they charged licensing or the trade value as 1250 rupees per packet of the seed. So, aggrieved by this, the Farmer Association Ratu Sangam of Andhra Pradesh had made a representation to at that time it made a representation to the Monopolies and Restrictive Trade Practices Commission, which that time regulate. There was no competition commission that time. So, this MRTP Act was in force. So, this Farmers Association made a complaint to this commission under MRTP Act in 2005 against Mahiko Monsanto. So, so this commission looked into the case, and they asked Mahiko Monsanto to reduce the price of this BG1 from that 1250, from that time reduce it to 900 rupees per packet. So, during its through this order, this MRTPC in 2006 is granted an order, and it observed that, I am just reading out that there is a basic difference between the royalty and the trade value, and they are not synonymous. Royalty and the trade values are different. In any case, the lump sum payment of 50 lakh rupees may be considered as a royalty for the same, but the future payments on the sales cannot be termed as the royalty. So, as I said, all this 40 company gave an upfront 50 lakhs rupees and again they were giving every time certain royalty values as the number of, as the seeds were sown or as the seeds were harvested. And this commission again held that it held by temporary injunction on the Mahiko Monsanto Biotech Limited is directed during the pendency of this case. So, not to charge the trade value more than 900 rupees for a packet of 450 grams of BT cotton seeds, and it should fix a reasonable trade value that is being charged by the parent company in other parts of the world like in China. So, basically the Indian seed companies were arguing that Monsanto was not only charging, like the charge of the Monsanto for this trade value is very high in comparative to the our neighboring countries like China and others. Like the famous seed like prominent seed companies like the Nuzividu seeds and others were like party to this thing, and they have complained the high charges of Monsanto. Again during that time, as the price all the state governments were in power of fixing the retail prices or the trade value prices. The state government of Andhra Pradesh was also like they have also fixed the trade values. So, the state government of Andhra Pradesh through its order in 2006 fixed the maximum sales price of the BT cotton seeds to 750 rupees. Which included the trade value. So, this was too far lower than the price which MMBL has fixed. So, for to this the MMBL filed an interim injunction and it gave an interim application to Supreme Court of India, and it prayed for a stay order on this order from the state government of Andhra Pradesh. Where Supreme Court listened to the prayer, but Supreme Court said that if MMBL was not adequately covered by the sum of the 750 rupees per packets as fixed, then the MRTPC shall decide as to from whom the balance, if any, shall be recovered. So, it is not that MMBL will be in power to fix whatever amount it can do, it wants to fix, but MRTPC will come into picture and it will fix the amount and it will decide from where it will adjust the amounts or recover the amount. Anyway, after this, the MMBL entered into number of settlement and release of claims agreement, and consequently they also entered into the supplementary and amendment agreement with the seed companies in 2007 and started charging rupees 148 nearly 148 rupees per packet on an MRP of 750 per packet as a trade value. So, now finally the conditions were little bit modified, and in 2007 they have modified the agreement and charged trade value of 148 rupees and 15 paise on the total packet on a packet of 750 rupees. So, during that time resolution of the MRTPC took place as the Competition Act was being passed, and the case was transferred to the Competition Appellate Tribunal or COMPAT. Now, the Competition Appellate Tribunal through its order in 2009 it gave a notice that it is allowed one time change in the pricing of this trade value, but however, it said that any further modification in the prices may give rise to further cause of action. So, basically it cautioned MMBL for further modification in the prices, and if there is any necessary modification it should inform the Competition Appellate Tribunal. So, that was the terms of events of thing which were happening at the backdrop, like the latest complaint was 2015. So, but the problem has started in 2005 itself. So, during this time also the Mahiko Monsanto Biotech Limited has filed a number of writ petitions challenging the orders by the various state government which has fixed the price of this trade value and this MRP, like Gujarat, Andhra Pradesh, then Uttar Pradesh, like all the state government has fixed the MRP as MSP as different at a different level. All the MSP were different. So, the MMBL has filed writ petition challenging their the fixing of those values and respective trade values. And then it also during that time also it has renewed the sub licensing agreements in March 2015 for the BG2 variety. And for the BG2 the trade value price was little bit higher, like the trade value was increased to 174 on the MRP of 1100 per packet in various state, because during 2015 the BG1 has become little bit obsolete. So, BG2 has substituted the BG1 variety, and BG2 variety, for that they were charging a little bit higher prices. So, but since the company were like seed companies wanted to sell those BT cotton varieties to the farmers, so they had entered into the licensing sub-licensing agreement with the Mahiko Monsanto. But since there was a dispute, so many disputes were going on, the Mahiko Monsanto also filed arbitration petition against 8 domestic seed companies whose market were nearly 65% of the total cotton seed market in India. It alleged that they have nearly 400 crores rupees were due from the it has the companies have to pay nearly 400 crores rupees for the BT cotton technology which they have taken from the Mahiko Monsanto company of India. So, in response to that, the Indian companies also filed a counter affidavit arguing that already they have paid more than 1300 crores rupees to MMBL over, and they have also given the trade value which is higher than the fixed trade value by the various state governments. So, from 2010, so they want their money back rather than they should pay more 400 crores to MMBL. So, you may understand the nature of litigations going between these parties. So, again it is a counter affidavit. So, the seed companies allege that the sub-licensing agreements between the MMBL and the seed companies are one-sided, arbitrary and onerous. Like they had to abide by their condition, otherwise the MMBL was threatening to stop the licensing and not to give the seeds to the company, and also the Indian seed companies allege that there were restrictive clauses in the licensing agreement, and it restricts the ability of the Indian seed companies or the informants to deal with the new technology provider even if it is available in a lower cost. So, there were certain restrictive conditions in the licensing agreement which did not allow the Indian seed companies to get any new technology against any new technology, even though it was available at a lower price than the Monsanto. And they also contended that the trade value is very much unfair and it is being unilaterally fixed by MMBL, which is higher than those determined by various state governments. So, they alleged Mahiko Monsanto for charging high prices, putting restrictive clauses. Among restrictive clauses, they were not allowed to take any new technology even if it is available and at lower prices. Further, if they were taking any seeds from any competitor, they have to inform Mahiko Monsanto in within 25 days or nearly 1 month, and if if they found not if they found in the breach of the contract, then they have to destroy all the seeds, and within some 2 years time frame. So, the conditions were very much restrictive, which is not suitable for them, and they were not allowed to take any new technology. So, as per the Competition Act, as we have already discussed, so anything which is contrary to our, which stops further innovation or which give or the price is higher price setting. So, this kind of practices are in general considered as an anti-competitive. However, let us see how this Competition Commission has looked into this matter. The seed companies were one party. So, at the same time, many of the private farmers association NGOs and farmers association also has shown their concern to the Ministry of Agriculture. So, basically Ministry of Agriculture showed its concern in 3 points. First, the abuse of dominant position of Mahiko Monsanto by charging unreasonably high fees for the BT cotton seeds, which is as per section 4 subsection 2 of the Act, a kind of abuse of dominant position. Second, exploitation of the permissions given by the government to market the BT cotton technology by creating monopoly through restrictive agreements for unjust enrichment by charging high trade value from its licensee and ultimately from the farmers. So, basically a permission is given by a state body or a central body to improve the societal condition, so that the farmers will get the cheaper variety and a new variety can be introduced that will be helpful for the farmer as well as the society itself. But by this behavior, Monsanto was showing a quite a monopolistic attitude, and it was charging high prices from the farmers involved. Third concern was regarding its sub-licensing agreements with the Indian seed manufacturing companies, and which were considered to be anti-competitive as per the provision of subsection 4 of section 3 of this act. So, this was the one side of the story where the objection or the complaints were going to Competition Commission of India for this thing. But one of the other way round also, there is the state of Andhra Pradesh, which is a major, which is the home to big seed companies as well as a major seed which has a major seed producing market. So, the state of Andhra Pradesh has written to Government of India to asking its power to invoke section 92. So, basically section 92 of this Patent Act is for issuing of compulsory licensing. So, the state of Andhra Pradesh asks the Government of India to issue a compulsory licenses for Monsanto's patents on the grounds that Monsanto is showing a monopolistic behavior, and through one-sided sub-licensing agreement is completely controlling the cotton seed farms and thereby collecting excessive royalties. So, under these provisions, the state government asked Indian government to issue compulsory licenses for the patented technology of the Monsanto. So, as you know, there are other section 84 is basically provision for compulsory licensing, where in case of non-working of a patent or there are certain grounds, if that does not is not happening, then any person can ask for the compulsory licensing, but the burden of proof is on the person who is asking for it to prove that is on substantial, he has to prove on substantial grounds that the patent is not worked in India, or it is not available in reasonable prices, or the other conditions. But this section 92 of this Patent Act is a provision where the which states that the central government in case of national emergencies, or in case of extreme urgencies, or in case of public non-commercial use, can make a declaration that a certain patent will be available for compulsory licensing. So, the benefit of this section is that the burden of the burden of proof is not on the applicant. So, basically the parties are relieved from the burden of establishing that the threshold required under the section 84 is not met, and they are only required to make application to the controller of the patents, who is required to grant a compulsory licensing on certain terms and condition. So, since the technology was the trade value was very high, and it was Monsanto is showing a monopolistic behavior. So, section 92 was the state government of Andhra Pradesh asked to invoke section 92. Also, it further requested, if possible, the patent may be revoked under section 66. So, this is this is to plea to the Controller General of Patents, but anyway we are more concerned here about the Competition Commission of the India. Basically, so all these complaints from these seed companies were like regarding the abusive conduct of the Mahiko Monsanto Biotech Limited. So, basically the abusive conduct were on the accounts of imposition of the unfair conditions in the sub-licensing agreements. We discussed about the restrictive condition, they cannot take any new technology, cannot interact with other competitive companies, etc., which are like kind of restrictive conditions. Second, the charging of unfair prices. Third, discriminatory treatment, like the pricing of this trade value was different in different countries. Then fourth one is limiting and restriction of the technical and the scientific development related to the BT cotton technology and the cotton seed markets. Next, denial of market access and leveraging of the dominant position in the BT cotton technology market to protect the cotton seed, and which are in the violation of the section 4 of this act. And it was further stated that the sub-licensing agreements between the seed companies and the Mahiko Monsanto Biotech Limited were in contravention to the section 3 subsection 1 and subsection 4 of the Act. So, these are the basic allegations of the seed companies against Mahiko Monsanto. So, while coming to a decision in this case, looking into investigating the case, first as first to understand what is the relevant product market in this case. So, the commission found that the BT cotton technology, by virtue of its effectiveness and the characteristics, is a distinct product, because by use of this technology, people are not using these harmful chemicals or the pollutants or the pesticides. So, basically the aim of choosing the BT cotton technology is to protect the cotton crop from the pest, that the bollworms, and in an effective and non-polluting manner by using the genetic variants. So, the upstream product market in this case were considered to be the provision for the BT cotton technology, and the relevant geographical market were considered to be India, because in India any genetically modified plant was approved by the GESE committee, genetically engineering approval committee, which basically looks into all the field trial data and everything, whether it is harmful or what kind of results are giving, which takes a long period of about 5 to 7 years. So, after only the GES's approval, any plant seed variety, genetically modified seed, can be cropped in India. So, in the Mahiko Monsanto's website itself, they have said that they got approval for this BG1 and BG2 variety from GESE in the year 2002 and 2006 respectively. Therefore, here the relevant market is India, because the market had started from 2002 itself. So, relevant product market was the upstream market for the BT cotton technology. And now coming to the dominance, abuse of dominance. So, first they have to establish whether Monsanto is the dominant player or not. So, because the relevant product market is the upstream BT cotton, genetically modified BT cotton technology. So, basically there were two types of cotton technology, as we know, BG1 and BG2, which in BG1 involved one gene modification, and BG2 involved two genes. So, here after detailed analysis, it was shown that the Mahiko Monsanto was the only player in the 2 gene BT cotton technology. In 1 gene BT cotton technology, there were some other research institute and companies were involved, but again it has a high market share, and but for in the 2 gene technology, Mahiko Monsanto was only company. And out of this 1128 out of the 1128 BT cotton hybrids approved by GESE in the year 2012, 986 hybrids were incorporated with the BT technology sub-licensed by the Mahiko Monsanto. So, from this, nearly 99% of this market was under Mahiko Monsanto's control. So, from this it was ascertained that Mahiko Monsanto Biotech Limited holds an dominant position, and then relevant product market was decided, relevant geographical market is also decided, and then it was held that Mahiko Monsanto is a dominant player. Now, coming to the abusive practices. So, basically commission holds that held that the conduct of Mahiko Monsanto was prima facie appeared to be in violation of the section 4. And the agreements entered by the Mahiko Monsanto as well as the sub-licensing, during this agreement, it had found to be appreciable adverse effect in the competition of the India, because they were the only company who were selling this BT cotton 2 variety. So, if somebody is not abiding by the royalty rates or all the restrictive condition, then Mahiko Monsanto was not going to give the seeds, and further they have to destroy all the seeds which they have produced. So, again this is a non-competitive it is not that easy for a farmer to destroy all the seeds or the crops. Again, they cannot do any research and development on the BT cotton technology. So, prima facie with all this investigation, Competition Commission of India established that there is contraventions in the provision of the section 3 subsection 4 as well as section 4 of the Act, and it is a fit case for the investigation by the Director General. So, this is one of these important case where we saw that restrictive condition in a licensing agreement and abusive behavior by a dominant player may lead to anti-competitive effect. So, we will continue further our discussion on the various IP licensing and Indian Competition Act in the next classes. Stay tuned. Thank you so much.